On July 17, 2026, a federal judge in Los Angeles confirmed that Cher had been right about everything. The royalties were hers. The 1978 agreement was unbreakable. The 5-year attempt to void it had failed completely. Then the same ruling told her she would have to pay the entire legal bill herself. Every cent of the $1,236,530 she had spent winning. She won. Let me be very clear about that before anything else. After 5 years of federal litigation, after hundreds of thousands of dollars in attorney fees accumulated across motions and depositions and oral arguments and briefings filed in the United States District Court for the Central District of California, after a series of rulings that built, piece by piece, toward a conclusion that was in the end both legally significant and almost completely logical, Cher won. The federal judge confirmed what she had argued from the beginning. The royalties were hers. The 1978 divorce settlement agreement she had signed with Sonny Bono was a binding, enforceable contract. The legal mechanism his widow had used to try to reclaim those royalties, a federal copyright termination provision, could not reach the financial terms of a California marital settlement. The songs that Sonny wrote and Cher sang and the world received as a unit were and would remain half hers in perpetuity. And then the ruling continued. The attorney's fees, $1,236,530, representing 5 years of legal work by a team of attorneys who had taken her case from an initial complaint through multiple rulings and toward what appeared to be a final resolution, would be paid by Cher herself, not by the losing party, by the winner. Because winning a case grounded in state contract law, even a case that touched federal copyright, does not entitle the winner to shift costs under the federal copyright statute's fee-shifting provision. She won, she pays, she keeps going. That is not a metaphor. That is the literal, legally documented sequence of events in Cher's life in the summer of 2026. And it is, in the most precise and unornamented sense possible, the most Cher thing that has ever happened. To understand why Cher spent $1 million in federal court at 80 years old to protect a piece of paper signed in 1978, you first have to understand where she came from. Because nothing about who she became makes sense without knowing what she started with. Cherlyn Sarkeesian was born on May 20, 1946 in El Centro, California, a small, sun-baked city pressed against the Mexican border where summer temperatures routinely exceeded 100 degrees. Her father, of Armenian descent, was largely absent. By the time she was old enough to hold a memory of him, he had already established the pattern of disappearing that would define her early childhood. Not by presence, but by the permanent awareness of his absence. Her mother, Georgia, was of Irish, English, Cherokee, and German descent, a woman who was beautiful, restless, and relentlessly trying. Georgia married 8 times over the course of her life. She worked as a model and an actress, chasing her own version of a dream while raising a daughter who would eventually catch it first and hold it far longer than anyone around her could have predicted. Cher has described that childhood with a particular kind of directness. Not bitterness exactly, but the flat clarity of someone who stopped looking for a softer framing a long time ago. There was no money. There was instability. There was a mother who loved her but was not always present in the way a child needs, and a father who was almost never present at all. What she had instead of stability or money or connections was a physical presence that even at 16 carried weight, a voice that was instantly recognizable, and an appetite for attention that was not vanity but something closer to a survival instinct. She knew she was meant to be seen, and at 16 she left. She moved to Los Angeles with no plan, no money, and the absolute certainty that El Centro was not where her story ended. In 1963, Cher met Salvatore Philip Bono. Sonny was 27, she was 16. He was working as a promotion man for Specialty Records, moving through the edges of the music industry with more energy and ambition than conventional talent. He was not a great singer. He was, however, a great believer, and the first thing he believed in with total conviction was Cher. He looked at a 16-year-old girl from El Centro and saw not what she might become but what she already was. The voice, the face, the stillness that could fill a room. He became her manager. Then her collaborator. Then, in 1964, her husband, in a ceremony so informal it barely registered as a legal event. They were married, they were broke. And they were about to change the sound of a generation. In 1965, Sonny and Cher released I Got You Babe. #1 in the United States and the United Kingdom. 4 million copies sold. An anthem adopted almost instantly by a generation that heard in it something real. 2 people who had chosen each other and weren't particularly interested in what anyone else thought about it. Cher was 19 years old. What followed was a decade-long run that would be remarkable by anyone's measure. Hit singles, films. And then, in 1971, the Sonny and Cher Comedy Hour on CBS, a program that at its peak drew approximately 30 million viewers per episode. 30 million people every Saturday night watching Sonny play the lovable fool and Cher play the woman who was too smart, too beautiful, and too funny to suffer him gladly. The comedy worked because it was not entirely fiction. Their daughter Chaz was born in 1969. The family was complete, at least on paper. And then, slowly and then all at once, it stopped working. Not the fame, not the brand, but the marriage. Cher has described the end in different ways over the years. The emotional core of every version is the same. She had outgrown something, or grown into something that the structure of that marriage could not contain. She was no longer the 16-year-old girl from El Centro who had been grateful to be seen. She was one of the most recognizable women in America, and she knew it. They separated in 1974. The divorce was finalized in 1975. 3 years after the divorce was finalized on August 10, 1978, Cher and Sonny signed a formal marital settlement agreement. The terms were specific and consequential. Cher would receive 50% of the royalties from Sonny's compositions, I Got You Babe, The Beat Goes On, Baby Don't Go, and the others. 50% of the royalties from the recordings they had made together. In perpetuity. For as long as the songs existed and earned money. This was not a gift from Sonny. This was not generosity. This was a legal recognition that what they had made together. That the voice on those records was hers. That the name on those albums was hers. That the money those recordings generated belonged to both of them, in equal measure, for as long as anyone was willing to pay to hear them. Sonny agreed. He signed it. For the next 20 years, the arrangement held quietly. Without drama, the royalties flowed. Cher received her 50%. The agreement functioned exactly as it was designed to function. Meanwhile, both of their lives had moved in directions nobody could have predicted in 1978. Cher rebuilt herself so completely across the 1980s that the Cher of the late 70s bore almost no resemblance to what came next. In 1988, at 41 years old, she won the Academy Award for Best Actress for Moonstruck. Then in 1998, at 52, she released Believe, a song that used pitch correction technology in a way no mainstream artist had attempted before, spent 7 weeks at #1 in the United Kingdom, and introduced her to an entirely new generation of listeners who had not been born when I Got You Babe was a hit. Sonny had moved in his own direction. He remarried in 1986 to Mary Bono, a fitness instructor 22 years his junior. He became mayor of Palm Springs. Then, in 1994, he was elected to the United States House of Representatives. The promotion man from a record label in 1963 was making federal law in 1996. Then on January 5, 1998, Sonny Bono struck a tree while skiing at a resort near South Lake Tahoe. He was 62 years old. He died that afternoon. Cher spoke at his funeral. She stood at the podium and said the things that only she could say about him. Not the polite things, but the true and complicated things. She called him the most unforgettable character she had ever met. She said he had made her who she was. She said it without bitterness, in the flat direct register that has always been her most honest public voice. The connection was real. The loss was real. And the 50% on that piece of paper from 1978 continued to exist, quietly and without disruption, for the next 20 years. Mary Bono, 40 years old at the time of Sonny's death, had been married to him for 11 years. She became the executor of his estate and was subsequently elected to Congress to fill the seat he had vacated by dying. She served until 2012. For 2 decades after Sonny's death, the royalty arrangement held. The money continued to flow. Nobody disputed anything. Then, in 2018, something changed. Not in the music, not in the money, but in the law. A provision of the United States Copyright Act known as the Termination Rights Provision had become applicable to a specific category of works first published in the late 1960s. The provision was designed to protect creators and their heirs from contracts that, over time, proved to have been signed away for far less than the works were eventually worth. Under this provision, creators or their heirs can reclaim rights that were previously assigned, regardless of what the original contract said. Mary Bono's legal team identified this window. They concluded that certain of Sonny's publishing rights, including the compositions whose royalties had been assigned to Cher under the 1978 divorce settlement, were now eligible for termination. Under federal copyright law, they filed termination notices. The notices stated the intention to reclaim those rights, including the 50% interest that had been granted to Cher more than 4 decades earlier. The legal argument was not frivolous. The federal statute does, in certain circumstances, allow termination of prior grants. The question that would consume 5 years of litigation was whether federal copyright law could be used to override a California state marital settlement agreement, whether a statute designed to protect creators and their heirs could be deployed to strip a former spouse of rights that a divorce court had awarded her as part of the division of a marriage. Whether what a federal law gave could be taken back by a federal law from someone who had received it not as a creator or an heir, but as a wife. In October 2021, Cher filed suit in the United States District Court for the Central District of California. She was seeking $1 million. She was arguing that the termination notices were legally meaningless as applied to her rights under the 1978 marital settlement agreement. The core of her argument was clean and almost elegant in its simplicity. Federal copyright law exists. California family law exists. They govern different things. The termination rights provision was written to allow creators and heirs to reclaim rights assigned away in commercial transactions, publisher agreements, label contracts, licensing deals. It was not written to allow widows to strip former spouses of assets that a divorce court had already distributed and that both parties had agreed upon. The 1978 agreement was not a publishing contract. It was not a licensing deal. It was a marital settlement, a different instrument entirely, governed by a different body of law, operating in a different legal universe. And federal copyright law, Cher's team argued, had no authority to reach into that universe and undo what California family law had already settled. Mary Bono's legal team argued the opposite. Congress had written the termination provision without explicit carve-outs for marital settlements. If the statute allowed termination of prior grants, they contended, it allowed termination of prior grants, including those made in the context of a divorce. The law was the law. Federal Judge John A. Cronstadt was assigned the case. In May 2024, he issued his first major ruling. Cher was entitled to more than $418,000 in royalties that had not been paid since July 2022. Royalties withheld by Mary Bono on the basis of the termination notices. The money was owed. It needed to be paid. The core question, whether the termination notices had permanently extinguished Cher's rights going forward, remained open. Then, on November 26, 2025, the day before Thanksgiving, Judge Cronstadt issued his final ruling on the merits. It was comprehensive and unambiguous. Cher maintained the right to receive 50% of the royalties from Sonny Bono's compositions in perpetuity. The termination notices had not terminated and had not in any way affected the 1978 marital settlement. The notices were legally inoperative as against Cher's rights under the divorce settlement. Federal copyright termination rights, as written and as intended, were not a tool for undoing the financial terms of a divorce. She was also awarded more than $187,000 in additional withheld royalties. It was by any measure a decisive win. Cher's legal team then asked the court to order Mary Bono to pay the attorney's fees, $1,236,530, representing 5 years of federal litigation conducted on her behalf. Under certain provisions of federal copyright law, a prevailing party in a copyright dispute can recover attorney's fees from the losing side. Cher had won. She had won comprehensively. She asked the court to apply that provision. On July 17, 2026, Judge Cronstadt denied the request. His reasoning was careful and consistent with the logic of his earlier rulings. The central question in the litigation had been primarily a question of contract law, California contract law, state family law, not federal copyright law. The fee-shifting provision Cher had invoked applied specifically to cases decided under the Federal Copyright Act. And while the Copyright Act was the instrument Mary Bono had attempted to use to reclaim the rights, the case had ultimately turned on state law contract principles. The fees provision did not apply. $1,236,530, her bill. For winning, there is a particular quality to that feeling. The feeling of having been entirely right about something enormously important, and of discovering that being right does not insulate you from the cost of proving it. The royalties are hers. They will continue to be hers. I Got You Babe will continue to play in films, commercials, streaming playlists, wedding receptions, and every time it does, Cher will receive her 50%. The financial victory is real and it is ongoing and it is significant. But the $1 million is gone, and Mary Bono has announced her intention to appeal the November 2025 ruling on the merits. The question that Judge Cronstadt spent 4 years resolving at the district court level will now be reviewed by a higher court. In a legal sense, the case is not entirely over. Here is what I keep coming back to when I sit with this story. Sonny Bono and Cher made those songs together. He wrote them, she sang them. The world received them as a unit. And when the marriage ended, the law of California said that what they had made together belonged to both of them, in equal measure, for as long as the music existed. Sonny agreed. He signed it on August 10, 1978. That agreement held for 47 years. It survived Sonny's death. It survived a congressional career, a second marriage, 2 decades of quiet royalty payments, a copyright termination strategy, 5 years of federal litigation, and 2 separate rulings from a federal judge. As of today, it is still holding. At 80 years old, Cher accepted the Grammy Lifetime Achievement Award in February 2026. She appeared at the Met Gala. She remained, as she has remained for 6 decades, entirely and unmistakably present. And simultaneously, she was in federal court fighting for what a judge in California decided in 1978 should be hers. She won every ruling that mattered. She paid the bill for winning. If that sounds like the summary of a career as much as the summary of a lawsuit, that is because it is both. The specific legal mechanism changes. The underlying dynamic does not. Cher wins things that cost everything. And then she gets up and keeps going, because stopping has never registered to her as a real option. The girl who left El Centro at 16 with nothing built something across 60 years that a federal judge has now confirmed belongs to her. The agreement that Sonny signed in 1978 is still standing. His widow's attempt to undo it has failed at every level at which it has been reviewed. She won. She pays. She keeps going. That is not a tragedy. It is not a triumph in the uncomplicated sense either. It is exactly what it has always been. The cost of standing your ground, paid in full. By the person who had every reason to, and every reason not to, and did it anyway. If Cher's story made you feel something, share it with someone who needs to hear it. And we'll see you in the next one.